Thank you for watching Truth and Justice with Vivian King. I'm so excited to have in the studio my former law professor from 1989. He's now a tenured professor at South Texas College of Law, and he has graciously offered to give some of his time tonight to explain some new Supreme Court cases, new in that they were ruled upon in 2017, and they're related to criminal issues, and so they're important to the criminal justice system and should be important to you. I also have Danny Sneed as a co-host tonight, who will also ask questions about these cases from a citizen's point of view. So Danny, if you can let Professor Williams take about 15 minutes to explain each case. We have 2 cases that we're going to talk about, maybe 3 if we can get that far. But first we'll start off with Moore versus Texas, which is a Supreme Court case. So Professor Williams, thank you for agreeing to come on tonight.
Sure. Why don't I start by explaining the whole process to the viewers,
That's very
how
good.
it all works. Okay.
And feel free to look at the camera if you want to.
Okay, sure. Okay. So when a person in Texas, there are certain crimes that are called capital crimes that the DA has discretion whether or not to charge someone with a capital crime and whether or not to seek a death. If that happens, the person gets a trial where the jury decides whether or not the person's guilty or innocent. Obviously, if the person's innocent, then the whole proceedings are terminated. If the person's found guilty in a capital crime, then what happens is there's a second phase of the trial called a sentencing phase, or mitigation phase. During that phase of the case, the jury has to answer 2 questions. One is, would the defendant be a future danger to society? And secondly, are there any mitigating circumstances which would warrant a life sentence? So basically, on the first question, is he a future danger to society? The jury has to answer that question unanimously, yes. And then on the second question, in order for the defendant to be sentenced to death, the jury has to answer unanimously, no, that there are no mitigating circumstances that would warrant a death sentence. So if you have a no on the first question or a yes on the second question, then the defendant is not sentenced to death. He receives a life sentence. And in Texas, it's life without parole or death. Those are the 2 options for the jury. So the jury has to find unanimously. So once let's say the jury decides someone is a future danger to society, and then they find also that there are no mitigating circumstances, the person is sentenced to death by the judge will formally sentence them to death. Then the person gets an appeal to the Court of Criminal Appeals. That's called a direct appeal. And basically that appeal is focused on the trial, what happened at trial. Those are the only issues that can be raised. Okay, then after that is decided, the defendant can file what's called a writ of certiorari with the United States Supreme Court. And then the United States Supreme Court only accepts about 80 cases out of about 8,000. So the chances of the Supreme Court taking the case is pretty slim. And then, so once the defendant files that, and if it's denied by the Supreme Court, then he can file what's called a writ of habeas corpus. He has to file that first in state court. He has to go back to the court where he was convicted. And he has an opportunity then to raise constitutional claims that his death sentence or his conviction was obtained unconstitutionally. So for instance, he didn't receive effective assistance of counsel, or maybe his rights to confront his accusers was violated. Some sort of constitutional right was violated. And it's restricted to just the Constitution. He can't raise anything that happened at trial that should have been, for the most part, raised during his direct appeal. So it has to be based on the Constitution. So like rules of evidence and that sort of thing, he can't pursue that. So once he does that, then he files another appeal with the Court of Criminal Appeals, if that's denied by the trial court. And then he would file another writ of certiorari with the U.S. Supreme Court. And then once that process is finished, that's the state habeas process, then he would go into federal court. And he would file a writ of habeas corpus with the U.S. District Court. Then he would, if that's denied, then he would file a appeal with the U.S. Court of Appeals here in Texas for the Fifth Circuit, which covers Texas, Louisiana, and Mississippi. And then after that's denied, he would file again a writ of certiorari with the U.S. Supreme Court. And the U.S. Supreme Court would basically be his last opportunity to prevent his execution. He actually technically can file a clemency petition with the Texas Board of Pardons and Paroles, but those are rarely granted. So for the most part, his last real opportunity to stave off his death sentence is with the U.S. Supreme Court. So that's just an overview of the process. By the way, a writ of habeas corpus is basically a request of a court that the person be released because the person is claiming that they're being held unconstitutionally. And that's what they file after they have been convicted and sentenced to death. They file that in both state and federal court. So that's kind of an overview of the process. It takes about, on average, about 10 years, but it can take longer than that, depending on the issues. And one of the cases I'm going to talk about, Martinez, my client, his case, he was convicted in 1984, and his case was still pending in 2017, but he died this past month. So he died of natural causes. So it gives you an idea what 34 years he was on death row. So the cases can vary in terms of length, but that's basically an overview of the process. So you wanted me to start with the Moore case?
Whichever one you like. I mean,
Okay.
maybe Martinez, since he died this year, get him out of the way. Martinez v. Davis.
Martinez versus Davis. Okay.
Now, one of the things I find interesting that viewers might want to know is when you see these death penalty writs, it's usually against the warden. So explain that process. That's interesting. So you might see a lot of cases, it'll be Buck v. Davis, Martinez v. Davis. So you'll see a lot of the same names instead of seeing the state of Texas as a party when it gets to the federal writ stage or to the writ stage. Explain that. You kind of explained it, but kind of tie that in to why the person who is held, the person on death row.
Why they sue the state official instead of the state.
Yes. Why do they sue? Why are the? I mean, and you can just tell us that that's what the rules count, but it's not going to be the state. So you can't tell in a lot of times what the state is. But our rules require. Explain that.
Yeah, sure. Well, when the person goes into federal court, the proceeding is actually a civil proceeding. It's not a criminal proceeding.
I see.
So that's why he has to sue the state official. And in federal court, the 11th Amendment, you can't sue the state in federal court, basically. So that's why he has to sue the state official when he goes into federal court. So yeah, that's why it's Martinez versus Davis or Buck versus Davis or, you know, one of those cases.
May I ask you another question?
Sure.
So when they're doing the state writ, then how is that style?
That's a criminal proceeding, so I know it can be confusing. But in state court, it's a criminal proceeding, so it goes back to where he got convicted in the criminal courts here in the state of Texas.
What would the style be?
The style would be the defendant, very like Martinez versus the state of Texas. Okay, but so when he goes to the entire state process, it's a criminal proceeding. But then when he gets to federal court, it becomes now a civil proceeding.
And so then the title changes.
And the title changes,
so
right.
if someone is trying to research someone's case all the way to the Supreme Court, if it's criminal, the names will change because of the rules that Professor Williams is explaining.
That's correct, right. So while they're in state court, it's always going to be, for example, my client Martinez versus the state of Texas, or Martinez versus Texas, in state court. So the entire state proceeding is Texas.
Even if it's the state habeas?
Even if it's state habeas, right, because it's a criminal proceeding. But then once he got to federal court, it became Martinez versus Davis, because he sued. Davis is the president, Lori Davis. She's now the warden. She's the person who's in charge of the prisons in Texas.
Okay.
Texas Department of Criminal Justice.
Right.
And so that's why she's the individual sued.
Okay.
So I have a question, because
Sure.
I was following the, you said that the first leg would be a direct appeal.
Right.
And that will be to the Supreme Court?
No, that's first to the Court of Criminal Appeals, Texas Court of Criminal Appeals. Then the person can file a writ of certiorari with the U.S. Supreme Court. So for instance, one of the cases I'm going to talk about more, he actually got his writ granted from state court. So
versus going back through the
federal
channels. So it's a very complicated proceeding. And if you make any mistake trying to do it yourself as a jailhouse lawyer, you'll get poured out.
Right, that's
And
correct.
so that's why it's very complicated, and you need a lawyer. So when you hear people say, and a lot of writ lawyers who might write a good writ, they haven't followed the proper procedure, and that's a lot of times why they get poured out.
That's correct. In fact, there's a doctrine called procedural default. So if you don't follow the procedures to the letter,
Right.
then they don't even consider your claim.
And I learned from you, Vivian, it's like a one-shot deal. If you
Right.
file it wrong one time, that was your own. You
Then
can't
that's
go
it.
back and say,
Right.
I want to correct the
That's
mistake.
correct.
Another question. So,
And let me tell you why that's hurtful, harmful. A lot of people who have been in prison for a long time will file their own writ. They think they've learned enough after 2 or 3, 5
Right.
years in prison, and they have a
Right.
life sentence or a 40-year sentence. And they learn educated people in prison who know a lot.
they go to the law library.
They do it themselves, but they don't realize they have one shot. And
Right.
so even if they go through the right process the first time, sometimes it's the first process, if it's not a death penalty, it's pretty simple because you do file it with the district court. And you're familiar with the district court because that's who sentenced you to prison. So that shot is usually the right shot. But if you don't have everything in it you need that a learned lawyer would need, because there's no point generally in filing a writ, even in state court, unless you have the money for an investigator to kind of investigate new or create or find newly discovered evidence that was not presented in the case.
Right.
You really you don't even really have a shot
Right.
shot in hell. Really.
Right.
I mean, you really have to have something new. That's why you hear of a lot of people getting out after new DNA techniques have excluded them from being the person who should be incarcerated. But it needs to be something new that wasn't in the trial. It can't just be my lawyer, I don't think my lawyer did this right. So a lot of people might on paper have a writ that reads well. If they don't go through the proper procedure, you get poured out. And a lot of times as a lawyer, you know, you really don't want to take people's money if you're a fair person because they've kind of already screwed up.
Right, that's
But
right.
they've already screwed it up. So usually when people call me, I'll say, has your son, who's been in jail 20 years, already filed his own writ? They always tell me no. It's kind of hard to find it, and it really costs you about $2,000 in legal research to kind of find out whether they did or not. It's not that simple to find out if they did it or not because I try to give them that consultation. I used to give them that consultation before I took their money. Because most people file their own writs in prison, I found.
Right, a lot of them do, yeah. Even in death penalty cases, I've had cases before where the client will file something in court, and that hurts them further along in the process. Because you've got to raise, you have to file all your claims in state court first. Any claim that you want to raise later on in federal court, you got to file them in state court.
You can't add on.
You can't, no,
Can't add
no, you
on.
can't
And
add on later. So, and a lot of them
it's very
screw up.
rule specific.
They'll write out something they think is good, and then, you know, I'll take over the case or some other lawyer, and there might be a legitimate claim, but you can't raise it because they have filed a writ.
The first time they didn't raise
Right,
it.
they didn't raise it, right. So it is definitely better that somebody, these inmates find lawyers to represent them as opposed to trying to do it themselves.
I mean,
No
unless
matter how learned they
no
might
matter
think
how
they are.
learned they are,
Right.
unless they're going to really dissect and analyze the code. I mean, they have
Right.
got to follow the letter of the code and
Right.
everything, and that's what lawyers are doing. We're reading the code and not just number one that says 11071. We're not just reading that. We're reading the whole code because you have to read the whole code because there are pieces that are not in that section that apply.
Right, right.
Yeah.
I have a great case now where the guy's on death row. You know, his mother, when she was pregnant with him, she used drugs and alcohol, and you know, he developed all kinds of conditions from that. And that claim wasn't raised, ineffective assistance of counsel claim wasn't raised in state court, and I'm trying to raise it in federal court, and basically the federal courts are denying it because they said, well, you didn't raise it in state court.
But you weren't doing it.
But I
He'd
wasn't
already
doing
done
it.
his own
Right,
writ.
right.
So let me be absolutely clear to our listening audience, and that if you're watching the show and you're listening, you have a family member that's incarcerated, and maybe he went down for murder, something that gave him a long sentence, and he's telling you, well, mother, I got this guy that's going to do a writ for me. He's charging me $500, put $500 on my book, and he's going to write a writ. From what we're learning here, that's not what he wants to do, because what he risked is filing it one time incorrectly and then not ever being able to do it
To raise
again.
good issues that might be relevant. So what he should do is he should if I were him, I mean, I can't really tell you what a person should do, but hypothetically, the proper thing is to write the letters to yourself of what you think what happened wrong, so that when you can find the money and you can find the time, or you can find somebody to do it pro bono, you have written down everything in your mind that happened, so that you can share that with a lawyer that is experienced in writs, because not all lawyers are experienced in writs.
Right.
And can
So
be
do
lazy.
your research.
It can be lazy also. But let's get into the cases. So
Okay.
which one do you want to do first? It doesn't matter.
Okay. I can talk about Martinez
Okay,
first.
sure.
Okay. So Martinez was, Raymond Martinez was my client, 1983, long time ago. He went and robbed a saloon here in Houston.
Saloon.
And that's what they called it back then, a saloon, and ended up shooting the owner of the saloon. So there were some other, so he was charged with that crime. There were some other crimes they actually used in the punishment phase that he was never actually convicted of, but they used it.
Unadjudicated offense?
Unadjudicated offenses, yeah. So he was actually charged with one murder, but they used 4 other murders during the punishment phase.
So they used that to show that he was a future danger.
That he was a future danger.
And remember, this case show is educational, so what we say has nothing to do with what we feel. It's the education of the process to the citizens who are watching this show. So, and remember, a capital murder has to be the death plus one other offense in the state of Texas. So that means that it needs to be, so in this case that we're talking about with Martinez, it's going to be the aggravated robbery with the robbing a saloon with a deadly weapon plus the actual murder in the course of that robbery. So those 2 first-degree felonies equal capital murder in the state of Texas.
Right. So they present during the punishment. He gets convicted. There was another woman in the car with him who testified against him, and also so that he gets convicted of the crime, and he gets sentenced to death. Once he gets sentenced to death, he actually got 2 reversals.
Wow.
Because of jury, one instance, there was a error in instructing the jury by the judge. Jury instruction, yeah. So that was one of his convictions were overturned for that reason. Then the second one was because at the time, the way basically Texas didn't. The procedure outlined, the 2 questions, they only asked back then 1 question. They didn't ask the mitigating question.
And that was declared unconstitutional.
That was declared unconstitutional, that you have to have some way for the jury to basically show mercy. Mitigation basically means mercy. So the jury has to have some way to have mercy on someone.
Give us an example of what that question is, how it's framed when they put it to the jury.
Sure.
Well, one example would be, is he a future danger? So they can show the 4 other times that he either killed or robbed or did something awful.
Anything he's ever done.
Everything that he showed bad, and then because you showed he killed his cat when he was 10, he slapped his teacher.
Right.
You know, like everything bad he did.
He had trouble in school.
He had trouble in school. He had fights in school. Truancy. He, raped a girl.
Right. Martinez said were burglaries.
These are convictions that they have?
No, they don't have to be convictions.
It's just bad conduct.
Just bad conduct that they can offer against it.
No. The people who has to come in that have knowledge.
They have to come in and testify.
Right.
But
they can subpoena your 3rd grade teacher.
Right.
And that wrote you up, 15 years ago.
If I'm on death row, or if I'm charged with a capital crime, and you say that I punched you in the face.
Y'all had a fight. You can testify and say he beat you up.
Even though I've never been convicted of it, you can come into court and say Kenneth Williams punched me in the face 20 years ago. He's a bad person.
So they find all his haters.
They find all that stuff.
That's what they do.
Right.
That's what the state of Texas does. They go back to when you were a little kid.
I had one client, they went back to kindergarten.
Yeah,
he acted up in school in kindergarten.
Right.
And they presented that.
They go out. They try to, so the state has the opportunity to show your life of bad conduct, just bad acts. So when it was unconstitutional, it was why all those adding up together on a board can be a powerful reason why you're a future danger.
Right.
And so what he's saying is back then is future danger, the death penalty. And that was like the first scheme Texas used after the death penalty was reinstated, because there had been a sabbatical period where the death penalty had been unconstitutional around the land in the 70s.
Before 76.
Yes,
right.
And then it came back. So every state has to create their own scheme that doesn't violate the Eighth Amendment.
Right. That's correct.
So every state has to create that scheme, and so Texas didn't have a good enough scheme. So when it was appealed by Martinez, the Supreme Court said, yeah, he doesn't have a way to show mitigating evidence, like show everything good that he did.
Well, for instance, he's paranoid schizophrenic. His mother was paranoid schizophrenic. He developed organic brain damage from working. He was from South Texas, and he used to go out when he was a little boy, and he would pick cotton. He has developed a condition called organophosphase, some kind of brain damage from the chemicals that was sprayed on the cotton. There was a psychiatric evidence of all this stuff. So there was significant mitigating evidence that he had, but he had no way to present it. The jury had no way to
hear it.
Hear it
because
or
that wasn't
give
a part of
effect to it.
Texas's first scheme as of 76 to 83 when this case was done.
It was actually presented, but the problem was that they were only asked one question: is he a future danger? So if you're a juror, you say yes, he's a future danger.
Because that's the only question you're asked.
Right. Back then, that was the only question you were asked. So even though you thought, okay, there were mitigating circumstances, and I really don't want him to get the death penalty, but if I'm honest, I can answer the future dangerous question, yes, because he did kill 4 people. He committed burglaries and robberies, and he had a real criminal record. So, but there was no way for me as a juror to actually give credit to his mitigating evidence.
So that was why it was reversed the second time.
That was a reversal of the second time. So the first time he got a bad jury instruction by the judge, and the second time because of the absence of that question, mitigating question. So he got a third.
So that was it. So he had a trial all over again.
He had a trial all over again.
So I mean, the trial.
Well, he got one new trial, and then he got one new sentencing hearing.
Okay. The first one was a trial. They didn't
the first was a trial, because the judge's instruction was a trial. That was a trial. So he got a totally new trial, and he got sentenced to death again, convicted and sentenced to death again. Then there was the mitigation issue. His sentence got reversed, not his conviction, but his sentence got reversed. He got another hearing.
But even though you call it a hearing, since I used to be a defense attorney and the practitioner, you have to present the whole trial again. So that they can answer the questions.
Right. Well,
so even though you call it a hearing, it's really all the evidence has to come back in. So everybody that testifies to a different jury, it's a different jury.
Oh, it's a different.
Yeah, it's a different. Okay. It's definitely a different jury. So it's a different jury. Yeah, you don't call the same people back in. It's whoever shows up for jury duty that day, that time. 5 years later.
The judge doing the sentencing?
No, judges don't do the sentencing.
No. The Supreme Court said a judge can't do the sentencing. It has to be a jury.
They have to answer these questions. Nothing's changed. So it's kind of like, roll with us, because it has to. It's the same. Yeah. So jury does the sentencing, answering. They don't sentence say death or not death. They answer questions, and the questions lead to the answer. So when the judge tallies up the question, like Professor Williams explained at first, and we'll go over it again at the end, so just try to absorb the whole case, because it's a lot. So, but I'm telling you, when he says a reversal in a second time, I'm letting you know that the trial has to happen all over again, because a new jury cannot answer those questions without hearing all the facts. What happened, and everything bad you've ever done, and everything good you've ever done. So that's a lot of money and time for the state.
Right. So he gets a third trial, and he gets sentenced to death again. And then after he gets sentenced to death, he goes through the process I explained, and the state court. And then I got involved in his case in federal court. So, and in federal court, I did an investigation, and I found out that he had a 65 IQ. And the Supreme Court, the United States Supreme Court, ruled in 2002 in a case called Atkins versus Virginia, that a person who is mentally retarded, they use a different term now, by the way, they call it intellectually disabled, but a person who is mentally retarded cannot be executed. Okay, and that's basically somebody who's mentally retarded, quote unquote, mentally retarded, intellectually disabled, somebody who has an IQ under 70, or somebody who's had difficulty in school, somebody who's had trouble adapting their behavior to society, just performing just basic tasks.
Is that grandfathered in?
Well, yeah. Well, the Supreme Court decided that in 2002. So any inmate after 2002 who had evidence
that... No, it's not grandfathered.
Right, so prior to, you can't go back.
That's not the way the law works.
Right.
That's not the way the law works, period.
Right.
All laws are from this point forward.
Prospective and not retroactive. There's a doctrine called non-retroactivity of criminal laws.
Right.
So they don't apply retrospectively. They apply prospectively.
I mean, that's
the
why
US
there
Supreme
was
Court.
not a that was the death penalty was ruled unconstitutional. So we killed people. Then there was a time that we didn't kill people. Then there was a time that we killed people. So it depends on when you committed a crime as to what you fall under, basically. That's the general rule. There are some exceptions, but that's the general rule.
Right, that's the general rule. So usually it doesn't apply retroactively. But say 2002, you had the decision, and then I started representing him in 2013. So that was well within, he could take advantage of the decision. So I did some research and found out that in school he was given an IQ test and he had a 65 IQ, and also he only finished the 4th grade. And some of the experts who testified at his third punishment proceeding said that he read at a 5th grade level. He had difficulty understanding basic concepts. So there was evidence that he had never held, and so he had a hard time adapting. He had never held a job. There were other indications that this is somebody who intellectually was disabled, had intellectual problems.
But under 2002, under Atkins, it was mentally retarded.
And mentally retarded, yeah.
And so the term did change.
The term changed, right. So the Supreme Court changed the term. So now it's intellectually disabled. Yeah, but back then he was considered mentally retarded. So I raised the claim that he was intellectually disabled based on the evidence, and Vivian talked about the new evidence. So in the federal habeas, I found some new evidence that he was mentally retarded. I raised that. The district court judge denied it. The Court of Appeals for the Fifth Circuit denied it. So I filed a court of last resort, the U.S. Supreme Court. I filed a writ of certiorari. 80 cases out of 8,000 the Supreme Court takes. They actually take his case, and they sent it back, and they said that this needs to be reconsidered because it looks like this man is mentally retarded, quote unquote, intellectually disabled. And while his case was pending in the Fifth Circuit, so the Supreme Court sends the case back to the Fifth Circuit to tell them you need to reconsider all this new evidence that he has. And because what happened was the district court and the Fifth Circuit wouldn't even consider the evidence, because the problem was that it wasn't raised earlier.
Right.
But there is an exception, which I brought out, but they still would not even consider the new evidence that I had. And so the Supreme Court sent it back, said, no, you've got to consider this evidence. There's some strong evidence here. This guy might be intellectually disabled. While his case is pending, about 3 weeks ago, I got a call from a reporter. Do you have a comment on your client, Raymond Martinez's death? President never called me. To this day, they've never called me. But this reporter called and said, do you have a comment on your client's death? And obviously that moots the case. So, but that was the big issue in this case. Was he intellectually disabled? And if he was intellectually disabled, then he could not be anybody who's intellectually disabled, the Supreme Court says, could not be executed.
So we'll never know.
So we're never going to know, right? Because the litigation's over.
Wow, that's interesting. So take us back to, let's go to Moore versus State.
Okay, yeah, Moore versus Texas. So
Texas, I'm sorry.
Yeah. So his case, the reason why it's Moore versus Texas, that was a U.S. Supreme Court decision, but his case got to the Supreme Court from his direct appeal.
Right.
So he got convicted. His direct appeal, the CCA, the Court of Criminal Appeals denied him. Then he filed the writ with the Supreme Court. Then the Supreme Court actually granted it. So he actually never had to go through the whole habeas process like my client did, Martinez. So in Moore was alleging that, well, the way the state decided who was mentally retarded violated the Eighth Amendment. So the Supreme Court in Atkins versus Virginia said, you can't execute someone who's mentally retarded, but we're going to let the states decide who's mentally retarded. You have to come up with that criteria. And Moore was alleging that, well, the criteria that Texas came up with wasn't really based on current medical science. It was based on old science. And the Supreme Court agreed with him that the way Texas was going about determining who's mentally retarded was based on old science. It wasn't based on contemporary science.
It was an old scheme.
It was an old scheme,
And
right.
more clinical studies have showed better ways to identify
people.
It was the wrong axis. I forgot. I had read it. It has to do with the axis that they were using.
There are
three. Yeah.
Right. Yeah, that's right. Basically, the state. The current definition puts more emphasis on what's called adaptive
Behavior.
That means like, can he function in society?
Like
Can he hold a
walk,
job?
talk?
Well, no,
No,
well,
no,
a little,
a little
bit than
deeper
that.
than that.
You know, what most people do, what do most people do? You get a job, you have relationships.
You can put your own clothes on.
You can, right.
No, not that basic.
Not that
Not
basic.
that basic.
No, but I
Okay.
mean,
You can be retarded and do that.
you can do
See,
retarded.
that's
Yeah,
not,
right.
retarded.
Intellectually.
It means that like
Challenge.
you're
I'm gonna say retarded.
you're intellectually disabled. You can't do things like well, you can't hold a job.
Right.
You can't develop
you can't have normal
relationships.
relationships because, you know, if you're mentally disabled, people have to basically take care of you. You know, they can't just say, you're not having intellectual stimulating conversation with people. They're basically
Right.
treating you like you're an 8-year-old.
Right.
You know, you don't really have a
You
stimulating
can't develop
conversation with
relationships with people because you don't have the intellect really to develop.
Right.
You don't have the skills.
someone
to
with
be
an
able to
8th grade,
develop.
8-year-old, a 10-year-old education is not an adult. You know, they're not adults. I mean, so they haven't developed completely. So that's,
Unless you find somebody with your IQ.
okay, but we're talking about the Supreme Court.
Okay, I got off.
Yeah.
Yeah.
So so the Supreme Court says you put more emphasis. Texas was putting more emphasis on like the IQ score. So if somebody had over 70, Texas was basically saying that, and also they had other criteria, like if you plan the murder. Well, everybody plans their murders. You know, for capital murders, they're all planned. So, but Texas had a criteria, very stringent criteria. So if you premeditated the murder, that showed that you were
think,
not,
yeah.
you can think and you can, you know, that sort of thing. If your family testified that you weren't intellectually, which, you know, they didn't have the skills to be able to make that determination. We're lawyers, we can't say somebody is or is
By
not.
looking at them.
Right, intellectually disabled, or even with
Even with families, because the problem with people who are mentally disabled or mentally retarded, if they are raised in a very intelligent family where they don't watch TV and all they do is talk, their conversation will be more intelligent. But that doesn't mean that they have the discernment to actually
Right.
be intelligent. So environmental factors can control certain things, but it doesn't control the organic need. Can they go out and really adapt in society
Right.
without someone that, you know,
Right, exactly. You know, somebody's 40, 50. Once you're an adult, you're supposed to be able to adapt on your own in society. You're supposed to be able to hold jobs and drive and vote and, you know, do things. Make decisions, right. And so somebody who's intellectually disabled, they have difficulty doing that. And so the current definition says you put more emphasis on that and not so much the IQ score. Because the problem with IQ scores is that, you know, different standards are used, different tests. Testers.
Yeah.
Right. So
there's a subjectivity in it.
There's
It's
a
not
certain
completely-
subjectivity. The environment has something to do with it. So you can have a range. Sometimes you have a range of scores.
People with IQs, even the ones when you go back to where Martinez was 65 in school, he might have one that's 68.
So you can set the questions up to get the kind of results.
It just depends.
It just depends on the. Well, for
Everything.
instance, the state tested him after I raised, and they found that he had like an 82.
Right, that's a big difference.
But that's a big difference, yeah. But the thing is, they found he had an 82 after he spent, you know, 25, 30 years in prison.
Reading and not talking.
Reading and,
right.
you know, in a very controlled environment.
Right.
And so, you know, and he's a much older person by then. And
So he had adapted differently.
And it's easier to adapt in prison, but especially for someone like that, because he doesn't have to.
He reads a lot, probably.
Well, you don't have to make decisions.
He doesn't have to make a
He
decision.
doesn't make decisions.
Everything's done for him in prison.
Right.
He has to make no decisions. Right. They tell him when to eat, you know, everything. When you exercise, you know, everything. So, but anyhow, that's an example of how the test scores can really fluctuate. So the current definition, medical definition, says you put more emphasis on the adaptive skills and not so much the IQ scores are important, but you put more emphasis. So you can have a situation, well, like Raymond, he had 65, he had 82. So you look more, though, to the adaptive skills than you do the IQ scores. Whereas in Texas, the way they were doing it, the 82 meant that's it. You're not retarded.
Right.
So if you had a 60, there were defendants who had, you know, 60, 68, 75. Oh, you're not retarded. You got a 75.
And there's also been questions in some of the cases where if they had a 65 when they were young, when it really didn't have anything to gain or lose by it, it showed that they had a low IQ.
Right.
But
yeah.
like once you're in prison or in the prison system and your IQ is higher, then maybe the testers have more to gain, so that they can
Right,
issue the
right.
death penalty.
Well, and the medical definition says you base it on their when they were children, when they were before they were 18. You don't base it on the fact that their IQ. You base it more on what they were like when they were 18.
Because the environment developed the decision processes that got them to that point to where they made it.
Well, but it's just unbiased at that point.
And it's
It's more unbiased, because once you start getting in the criminal justice system, the prosecutors will have their set of testers, and then the defense will have their set of testers. So they won't be the same, and so there can be more bias. But if you had it done when you were in the 6th grade, there's no real bias, because schools have an incentive for people to go to school and to be able to learn. There's no incentive not to learn.
Right. And the irony with Texas, what they were doing was in schools like HISD, they were actually using the current definition of intellectually disabled or mentally retarded. They were using the current definition, the current medical definition. They were only using it for the old definition for deaths for inmates.
Well,
and the Supreme Court pointed that out. That was very damning to their position in Moore versus Texas. So, all the school districts in Texas were using the current medical standard for determining who's intellectually disabled, whereas only for deaths for inmates, they're using the old standard. Right, exactly. Wow. So that really got them in a lot of trouble, right, with the Supreme Court. The Supreme Court, pointed that out. There would be no logical reason to use the new, because they administer the test in schools because they've got to figure out what kids need special ed and that sort of thing. So they're using the right standard for the school kids, but for inmates, I guess they don't care about. They want to execute them, so they just use the old definition.
Wow. So what's the status of Moore?
So Moore was, the Supreme Court granted his case and ruled in his favor and sent the case. They always sent it back for a proceeding consistent with our opinion. And so he's now pending in state court in Texas. They sent it back to the state court because he had never reached federal court. And the state has to decide how to proceed. The state courts have to decide how to proceed in determining whether or not he's intellectually disabled. But one thing that's clear, they've got to use whatever method they use. They've got to use a current medical definition for intellectually disabled.
But that don't mean he get out and walk out.
No, he's never. No. He only will. It only means that he will get a life sentence.
Life without parole.
Life without parole, right. So somebody who's intellectually disabled has nothing to do with their guilt for the crime, right.
It has to do with the violation of the 8th Amendment. Is it cruel and unusual? So the Supreme Court has decided that
it's cruel and unusual to execute somebody who doesn't have the full mental capacities, because they didn't really fully understand the consequences of what they were
And that's the 8th Amendment.
The 8th Amendment, right.
That's what
cruel and unusual punishment.
That's what all death penalty cases are geared toward. I mean, it could be
there is other issues,
but
yeah,
that's Confrontation Clause,
Sixth Amendment, Strickland,
ineffective. But generally, when it comes to the punishment part of it,
it's usually an 8th Amendment.
It's 8th Amendment on the punishment part. Guilt, innocence can be some other things like the Confrontation Clause or whatever. But the punishment part of it is generally the 8th Amendment. So we don't kill people under 18. We don't kill our children because in Texas, a 17-year-old is an adult for the criminal justice system, and they can get the death penalty at one point until the case.
But not now.
Yeah, in my career as a lawyer, they got the death penalty.
Right.
But
Supreme Court ruled that someone who committed the crime when they were under 18 years of age cannot be executed. So,
and I forgot the name of that case, but that was in Florida, right?
No, that was in Missouri. Roper versus Simmons.
Okay, yeah, Roper. Yeah, so that's the kid case. So there are certain categories that it's unconstitutional to kill certain categories.
Right. Those two, intellectually disabled, mentally retarded,
under 18,
and then anybody under 18 when they committed the crime. Not because the appeals are so long. By the time they are ready for execution, they're well over 18. But it's at the time of the crime where they under 18. If so, they cannot be executed. So even though they can be tried as a juvenile, and I guess you could charge them even with a capital crime,
yes,
right?
You can.
But you can't actually go the next step and seek the death penalty against them if they were under 18. So even if by day, I had a friend who had a client who 2 days before his 18th birthday committed the murder. He could
never be executed.
He can never be executed.
They can get life without parole.
Right.
In Texas, they get capital life, but it's actually less than life without parole for the 17-year-olds. It's I think it's 40 years. It changes with different legislative sessions, but it's about 40 years right now.
Oh, okay.
Yeah.
Okay.
So they don't get the real life without parole.
Okay.
At this time.
Okay.
But it changes. And when Roper was decided, it was decided in our legal careers. There were quite a few people on death row from Texas that were 17.
There were 17
when they committed the crime. So that affected quite a few cases.
And that was actually one of the few cases where the Supreme Court did apply it retroactively. Yeah. So anybody who had been
who was on death row in the United States when Roper was decided, that was applied retroactively.
Right.
That was one of those rare times that it does happen. Generally, it doesn't.
Right. That's right.
But sometimes if it helps you, they will do it retroactively.
Sometimes. Yeah. Right.
What I would be curious, has anybody ever filed upon the racial disparities? Like, okay,
yeah, they have.
I'm black,
yeah.
and look how many black people you executed.
Well, one of these cases talks about that a lot, and that is
McCleskey versus Kemp.
Yeah. Okay, that's the main case. But they talk about it in Buck, don't they?
Yeah, and they talk about it in Buck. Yeah.
Buck versus.
But Buck was not. Buck was specific to what had happened here in Texas.
Right.
McCleskey was a more general.
Because speaking specifically with guys, because you guys, I don't know what you guys are Buck and
Yeah, right, yeah.
Let's talk about Buck because it's Texas.
Okay.
If you don't mind.
And then we can talk about McCleskey.
Yeah, McCleskey is before then. Actually, it's before then. We can talk about, that's the history. So you want to go McCleskey first? Because we have time.
Do we have enough
time?
time? Okay.
We have 15 minutes.
Okay. So McCleskey was a death row inmate in Georgia, and he killed a white police officer. And he said that his claim was that it was a violation of the Equal Protection Clause to sentence him to death and execute him because he was black. He only got the death penalty because he was black. And to support that, he had a study that a professor at the University of Iowa did called the Balder Study, which showed that anyone who kills a white person was more likely to be sentenced to death, much more likely, like 80% more likely if you kill someone white as opposed to if you kill someone black. So half the people in America who are murdered are black, but very few of the killers of black people end up on death row. Basically, most of the guys on death row now, even today, most of the guys here in Texas and across the country who are on death row because they kill someone white, not because they kill someone black or Latino or Asian. Okay, so that was his claim basically. I'm on death row because I'm black.
And I killed
someone white.
And he had the Balder study to back that up. He showed all over the country that was the case. Okay, so it had nothing to do with the severity of the crime. It had more to do with the race of the defendant and the race of the victim. And the Supreme Court acknowledged the study. They said the study is legitimate. There was no problem with the study. The Supreme Court said, though, you can't base your claim on statistics. You have to show that the prosecutor or the jury discriminated against you in your case. So you can't
based on that you were black and your victim was white.
You have to so if I'm sentenced to death by jury, I've got to show that the prosecutor or the judge or the jury discriminated against me. I can't say, well, look at all the black people on death row here in Texas, or the black people on death row for killing white people. I have to show that the prosecutor, the judge, or the jury, in my case, discriminated against me. Well, that's impossible.
That's an impossible
yeah,
standard.
How can I prove that?
You can't.
Right. I mean, the jury, for one thing, deliberates secretly. They don't have to justify what they did.
Right.
So it's impossible to, what judge is going to admit, oh, yeah, I sentenced this guy to death because he's black? And what prosecutor is going to admit that?
And what jury is going to miss that? And you can't ask them anyway.
Right.
So let's get on to Buck.
Okay, so Buck. Buck was a...
Buck v. Davis, the same warden. Is Lori Davis.
No, actually, it wasn't Buck v. Davis. It was, Buck v. Davis. I'm sorry, I was thinking about Moore.
Oh, yeah.
So yeah, Buck versus Davis. So it was a Harris County case.
Yeah, I know that case.
So again, the jury in Texas, it was a sentencing phase. There's no question about his guilt. It was a sentencing phase issue. He presented an expert who testified. His defense attorneys presented an expert who testified that. Because Buck was black, he was more likely to be a future danger in prison.
Now, wait a minute. Let's stop. Hold the presses. The defendant's lawyers got an expert to say that black people
and Hispanics too.
And Hispanics were more likely to be future danger
because they would be dangerous in prison.
They would be dangerous in prison. So just think of that. Now remember, you're trying to mitigate future danger on the defense side. The prosecution shows that the person is a future danger by going back to grade school. The defense is supposed to show all the good things they did going back to grade school to try to counter that so that hopefully it flushes out. But think of what we're saying. The defendant's lawyer presented an expert that's supposed to show he's not a future danger, but in fact,
argued that to the jury, based on his studies and his work, that Buck was more likely to be a future danger, and if he received a life sentence, he'd be dangerous in prison because he's black. He claimed that, he would join these gangs, Latinos also. He said blacks and Latinos were more likely to be sentenced to death.
So what was the alternative if
hold on, let's just go with this case first before you ask any questions. I want you to understand the whole case.
Yeah, so his lawyers
I told you what the alternative was. So,
right.
The alternative is your lawyer is supposed to show that you're not a future danger. So he showed he was. But just think of this. Your lawyer is standing up, paying an expert to come and say that you're black and you're a future danger.
And if you're a jury, what other decision would you reach?
You're going to go by what that expert says.
Yes, especially the defense's expert. Yeah, right.
That's the prosecution's expert.
In fact, the Supreme Court pointed that out. The jury probably gave the expert more weight than had it been just a prosecutor's expert. Maybe they wouldn't have given him as much weight, but they gave him more weight because it was coming from the defense. If I'm telling you that, well, you need to kill Vivian, if you're on a jury, and I'm telling you, I'm her attorney, I'm saying,
kill her,
well, she's going to be dangerous.
Kill her, she's dangerous. Kill her, she's dangerous.
Yeah,
don't let her live.
You're
don't
probably
let her live.
Go ahead and say, okay, well, they're saying.
Well, maybe they did it intentionally so it could file an appeal for.
No, you wouldn't have done that, especially in Texas.
Only 0.5% of appeals are
successful. So you wouldn't.
So remember that. So why would you do that when you have no chance in hell? I mean, why would you do that? That's not the statistics. So under a fraction, only half of 1% of all cases in the whole state are won, and half of those are by the state.
So Buck goes through the whole process that I explained. He gets to the U.S. Supreme Court, court of last resort. Supreme Court looked at the case, and the Supreme Court said, this is ridiculous that the jury had to have decided the case based on race. The jury had to have decided that because he's black, he's a dangerous person, therefore he needs to be sentenced to death. And the Supreme Court said, well, you can't consider race in our courtrooms. That's a pretty powerful opinion. They said, when you're making these decisions, race can play no part. Justice Roberts wrote the decision. He made a really good statement. He said that the testimony that the defense presented, quote unquote, and I'm quoting him, appealed to a powerful racial stereotype that a black man is violence prone.
That's powerful.
Right.
And
Roberts wrote that, who's a conservative judge, appointed by George Bush, a Republican judge.
And didn't they also, I don't have it in front of me, but didn't they also talk about the toxicity of it? Didn't they use
it was toxic, and they said the jury had to have given it a lot of weight because they said had it been presented by the prosecution, they might have discounted it. But because it was coming from the defense, well, they gave it more weight. So the claim was actually ineffective as a counsel.
For putting on something that hurts your client.
That's what I was saying. I know it's kind of like far-fetched to think that they did it intentionally, but that's what they eventually.
No, a defense attorney's job is to try to get you to be found not guilty.
What was his motive to present something that's not?
Don't even think like that. Don't even.
Right.
It's a waste of time because you're trying to. If all you're going to do is get somebody to prove that they're not a danger, then why didn't you just prove evidence that they're not a danger? I mean, why would you not prove they're not a danger and have somebody isolated on death row for 20 years? Well, they could have been in general population with a life without parole sentence. So why would you punish your client like that?
And I'm asking you, what was his motive?
There's no motive.
They were probably just incompetent.
If 10 years, but listen to what you're saying. This is what you're thinking. You're thinking that the lawyer wants their client to be on death row where they're in isolation all day for 10 years before a Supreme Court reverses it. And the Supreme Court only takes, 80 out of
8,000.
80 out of 8,000. So why would you want your client to be isolated? That's cruel and unusual punishment. Why wouldn't you just try to go for the gusto and get them life without parole, a life sentence, so they can at least be in the general population? What reason would that be in your mind?
That's your best shot, man, if you can file for ineffective counsel.
No, your best shot is to get the jury to say, all you need is one
Their best shot is not guilty. All you have is one jury to hold up, and then you get to start over.
You get one juror.
Here's what I propose. Without him filing under that, what would he have filed up under?
Well,
It's a whole
14th
bunch of issues.
Amendment,
It's a whole bunch
he
of
could have
issues.
claimed equal protection that the
Under the
jury,
law.
because they considered race, that was a violation of equal protection. The problem is that the reason why
he's not on that level right there. What he's
Okay.
asking you is what else could he have done? What else?
Oh, the defense attorney?
With the
If
defense
that wasn't on
attorney.
the table, if
The
that wasn't
defense
on the
attorney
table,
should have done what I've
He should have
discussed
tried to
earlier.
find things in his
Find people
background.
to show that he's a nice guy.
He's a nice
that he
guy, or
walked the
that
lady
maybe he
across
was
the street.
abused,
He was abused, but jurors don't
physically
really
or
care about that.
sexually.
Let me tell you what jurors care about. Jurors care about the good things in life.
that he
did.
went to church
That
regularly.
he went to church.
He was from a good family.
His grandmother
Right.
got polio, and he would, no matter if he was out robbing people, every Sunday.
Maybe his mother used drugs when she was pregnant for him. Maybe that had some impact on him. Something like that for the jury to have some
feel
sympathy
for him. So, because you're trying to get him not to kill him. So, because nobody wants to be on death row because you're isolated for 23 hours of the day.
Well, in Texas, you're likely to be executed. If you end up on death row in Texas,
Texas,
you're probably going to get executed.
Right.
What
So
I'm
you
saying
wouldn't.
We
if
know
his-
what you're saying.
if his lawyer
You're
would
saying
have
basically he
presented
threw the
that,
case.
no, I'm
so he
saying
can-
if
for
he
his-
never would have presented that,
But he would have presented what?
something positive,
Right.
what would he have appealed on?
It's a whole bunch
Well,
of
there
things you
could
can
have been other
appeal
things.
on.
Because that would have been on the table.
No. This is because you're thinking there was one appeal. When these appeals will come up, they might have 25
There might be
issues.
25
We're only talking
issues.
about one.
Oh, that's the
Yeah.
one that they.
Yes.
Yeah, the Supreme Court granted.
That
on
usually when
one
you go
that
to the
issue,
Supreme
you might have
Court-
25 issues. You
Also,
might
those
have
other
30.
things listed.
Absolutely.
Usually when you go to the
Absolutely.
Supreme Court, though, you want them to focus on, because they grant so few, you want them to just focus on one issue.
thing.
So you want to write, like I wrote a 25-page brief at one issue, because you file a 100-page brief, they're not going to focus.
They're not going to
just
read.
gonna
Yeah, they can't be all over the map.
Right, exactly.
Because they're deciding things for the whole country. They're not
Right.
thinking about you.
Right.
It's not about you.
You have
it's
to show
about
that there's large ramifications to their decision. It affects the
the
whole
whole
country.
country. Yeah, so they're not worried
not
about
just
one person.
one person.
People rob
Yeah.
and kill and die. So that's not their issue. Their issue is fairness across the country. Is it fair for us to kill our children,
And if
even
it's
if they're robbers?
constitutional or unconstitutional.
Well,
Right.
it's all about constitutional. All about constitutional.
But
You
they're
don't go to
concerned
the
about-
Supreme Court unless it's
They're
constitutional.
not concerned, like if you're on trial and because you feel like you had an unfair trial, they're not going
They
to
don't
grant
care
your
about that.
case
Yeah.
just because, even
How
though
you
they
feel.
might have been unfair.
Yeah,
even
we
if
have
it wasn't
380
fair.
million people in the
Right.
country, so they can't. And we
You have to
9
show that this
jurors.
is something that will affect people not just in Texas, but maybe in Louisiana, California, Mississippi, Georgia.
Okay.
Whatever happened to you will affect a lot of people across the
So
country.
if Texas is killing 17-year-olds, that affects the whole country.
The whole country, right.
That's not just affecting Texas. So they're saying, look, as a public policy,
We don't want
We don't
people who are 17 or 16.
we don't
be
want to kill our
executed,
kids,
right?
even
Anywhere.
if they're killers.
right.
We're not going to kill our killer kids. That's just not bad. So we're also saying the Supreme Court is looking at policy, big picture.
Right.
They're not
The
looking
big
at
picture.
did you do it.
Right.
They don't.
They're
That's
not.
for the state to decide.
Right.
They're trying to find out was the process fair, and are we going to make a policy statement? So they're not worrying about the little things. So when you say what could the lawyer done, this is not the only thing they appealed. They've appealed a whole bunch of things all through the process, and it winds down to be one thing that goes to the
Okay.
Supreme
Supreme
Court.
Yeah. So they
They've
probably
lost
had
on
25
issues.
Yeah.
Every-
But
on
then
every step that he
was
explained.
so what they decided of those 25, what's my strongest issue for the get the
That's
Supreme
what I
Court
was trying to-
to
okay.
consider my appeal? And obviously this was the strongest issue, right? The other thing about the Davis case was that this expert had actually testified previously for the prosecution in about 8 cases. All those 8 cases were reversed. John Cornyn, who's not a senator, was the AG at the time. He asked the courts to reverse the conviction, the sentences in those cases, because the same guy testified against about 8 or 9 other Black and Latino death row inmates.
So it showed he was
that they would be
biased.
dangerous. Right, that he had given his testimony
Well, it's not
before.
necessarily that he's biased. It's just that this is the way he practices. Race is a factor in his analysis.
In his analysis, he believes that
Black people are more
and
violent.
Latino
Are more
were
violent.
likely to be violent in
So
prison.
he's out of a job right now.
Well, I mean,
Well, probably nobody would hire.
he's probably
well,
a
and that's the
psychologist.
point.
Yeah, he's
The-
probably a psychologist. Not for that. He might be the one that's on staff at a prison counseling
Mm.
people. He's a psychologist. So the person who testifies, that's not their only job.
Yeah,
you see what I'm saying?
true.
That might be.
Right.
That might
oh, yeah,
be. They
he
might.
probably
that's
does
a-
all kinds of stuff.
He does all kinds of
Yeah.
things.
Yeah,
I mean,
but-
so it's hard to get people to come testify. So that just might be one study that he'll testify for. That's not making him any money for death row people because the state is paying him. So
Right.
whether it's the defense or the prosecution, the state is paying him because most people on death row or defendants don't have money to hire their own experts.
Right. So that's those defendants get lawyers throughout. If you're on death row, right? You get paid.
Believe it or not, we have 3 minutes. I'm getting a 3-minute sign. So,
okay. Sure.
So on Buck, is there anything else interesting on Buck? And what do you think from an educational standpoint? This is good. This is good and intellectually, but from a layperson standpoint. Danny, for you to be someone that's gone to prison 3 times, serving a total of 15 years, how have you been enlightened?
Well, because I do the prison show every 6 weeks, and it's a platform for me to speak directly to people that's incarcerated. This is going to be valuable information to give them, especially on the writ part. Because the 15 years I served, I've seen a lot of jailhouse attorneys spend most of their life in the law library and soliciting the person with the need, these people of life sentences. So they get their parents to put money on this guy's books. I'm gonna do your writ for you. Now my understanding is this, that if it's not done procedurally correctly,
then they're not gonna.
And he's putting all this hope and faith. So what I would tell someone is, instead of telling your parents to send you money for ramen noodle soups and coffee, that you should get your family to get together and find your attorney.
Right.
Writ attorney.
A writ attorney.
attorney.
Yeah, not someone who's written a lot of writs.
Right.
That
Not
understand the
just
procedures.
So if you got a niece or a nephew or someone that's down there, you know they're not going to ever get out, and they're on death row, or they got life up with parole.
Save all your money and shoot your best shot.
And find you a writ lawyer who understands the process, because not a trial lawyer who goes to trial.
Oh, you for hire?
They're not gonna.
Can we hire you?
You can't talk about that on this show. We don't talk about that on this show. He was a college professor, and he is here pro bono to explain the process. He is not a writ lawyer. He is not a lawyer for hire.
Okay.
He has a job.
Okay. Right.
So that is what we do. So no. So he's here to enlighten people, because I used to and still do get a lot of letters from people in prison, and that's very hard to explain to a family. That you can't use that because they don't understand a process. They think
They don't understand the process.
They think that, well, even to tell someone that it's a process, most people in trouble believe that you're lying to them.
And you're lying to them, and you're putting them off.
You're putting them off. You just really don't want to do it.
Right.
You don't really have
That's right.
time. They don't understand how complicated. It's complicated for lawyers. The writ process is complicated for lawyers, and that's what you need to understand. And that's why I'm so excited that my law school professor from 1989 was gracious enough to come tonight and explain something about the death penalty to the viewers of Harris County and all over the country that watch this case. Thank you, Professor Williams, for your expertise.
Sure.
And you're willing to share. And will you please come back again?
I will. Yes.
All right. And thank you, Danny, for asking your candid, everyday questions that we need answers to, because this is an area that most lawyers don't understand. I've had lawyers email me all day, text me that they're watching tonight.
Okay.
Trial lawyers.
And the simplicity of how you put it makes a layman like me understand. I could follow it.
Okay.
And it's like 10 different steps that goes into this process, but it's a 10-year
process. Martinez was on death row for 34 years. Thank you for watching Truth and Justice with Vivian King. We're excited to be here, and we're here every 2 weeks, right here at 6:30 at Houston Media Source. Good night.
Good night.